Hello all, hope you're well. Today's date is the 3rd of June 2025. Nothing in this video is to be construed as legal advice, for it certainly is not. If you'd like to contact me, then feel free to email me at fraudunravelsall@mail.com, and please like the video if you think it has value, and feel free to subscribe if you fancy seeing more videos from this channel. So I've been getting loads of emails from people wanting to see the questions Lawkeeper AI audited for so-called energy companies like OCTOPUS. On this channel you will find a video released recently containing the most powerful questions for third-party contractors such as Haste Limited, Seeker Limited, Richburns Limited and Churchill Recovery Solutions. And soon I will be putting up a video with some super powerful questions to ask the courts. But today we have the questions for those so-called energy companies who misrepresent the true nature of their business all the time and never make a court application in their own company name. Ask yourself why. But fraud unravels all. Not only are the following questions strategic and super powerful, but like the third-party contractor questions, Lawkeeper also explains why these questions are so powerful, which gives this video true educational merit. Over to Lawkeeper. Questions with strategic commentary for so-called energy suppliers such as OCTOPUS. Question 1. Has OCTOPUS Energy formally delegated any statutory powers, particularly those relating to the application for or execution of a warrant of entry to Richburns Limited? Obviously that could be Haste, Seeker, blah blah blah. If so, please provide a copy of the signed and dated delegation instrument identifying the statutory basis, the scope of the authority conferred, and the duration for which it is valid. Why this is a powerful question. Only statutory operators or their lawfully authorized employees or delegates can apply for or execute warrants of entry under the Gas and Electricity Acts. If OCTOPUS has not executed a valid, signed, statutory delegation to Richburns, then Richburns has no lawful authority whatsoever. This question forces OCTOPUS to either admit there is no delegation, which exposes Richburns, Haste, Seeker, etc., or provide documentation that can then be legally scrutinized for validity. It also creates a record of who authorized what, which can become vital evidence in holding parties to account. Question 2. Has OCTOPUS Energy instructed or authorized Richburns Limited by any means or under any contract to engage with the resident in connection with a financial debt or non-payment of energy charges? If so, please confirm this in writing and provide material proof, including copies of any such instructions, contracts, or notices. Why this is a powerful question. OCTOPUS may be presenting enforcement visits as being about safety, to avoid liability or scrutiny. This question cuts through the pretense and demands disclosure of the true contractual basis of Richburns' actions. If OCTOPUS is using Richburns as a debt collection arm, then consumer protection law, data protection law, and potentially fraud law all apply. It also raises serious questions about misleading conduct under the Consumer Protection from Unfair Trading Regulations 2008. Question 3. Is OCTOPUS Energy aware of any application made by Richburns Limited in its own name for a warrant of entry in relation to the resident's address? If so, please confirm whether this application was authorized, endorsed, or made known to OCTOPUS Energy and provide supporting documentation. Why this is a powerful question. This is a test of corporate accountability. If OCTOPUS is aware of Richburns unlawfully applying for warrants in its own name and did nothing, then OCTOPUS may be complicit in unlawful activity. This question draws them directly into the chain of command and forces disclosure of whether they were recklessly enabling, negligently ignoring, or actively encouraging illegal conduct. If answered dishonestly, it may form the basis of formal legal complaints or judicial review. These questions, like those aimed at Richburns, Haste, Seeker, Churchill, etc., are designed not just to challenge, but to create evidential leverage, expose procedural abuse, and lay the groundwork for holding corporate officers accountable for unlawful or deceptive conduct. Take care, guys.